Okay, so good morning, everyone. My name is Anna Hughes. I'm the Director of Trust with the Arc of Northern Virginia. We are excited to host this live presentation on a very important topic, considering special needs trusts and real estate property. We are joined by two wonderful presenters, Cindy McDonald. She's the National Director of Philanthropic Advice with KeyBank. KeyBank also serves as the Arc of Northern Virginia's appointed trustee within our Special Needs Trust Department. And then we also have Jenn Crane, who is an experienced trust and estate attorney with Odin, Feldman, Pittleman. She specializes in special needs and elder law. With that, let's dive in. So Cindy, Jenn, thank you for being here, and we'll go ahead and get started.
Great. Thanks, Anna.
Of course.
So we can go right to the first slide. One of the reasons I'm here is so with KeyBank, so this is KeyBank's 200th anniversary, I will say that. So we are 200 years old this year. So excited to be partners with the ARC and able to have this conversation today. But one of the big things I want to kind of impress upon when we're discussing real estate and special needs trusts is we're a fiduciary first and foremost. So everything that we want to do, we want to make sure is in the best interest of our beneficiaries and our families. So what does that mean? You got to have a conversation. It always starts with a conversation. With that, we've developed so many great procedures and processes around real estate and really kind of opening up with lots of great questions for families to kind of really sit back and digest and think about things they may not think about as they're in their planning process or thinking about before they get to their planning process. So I'm going to share with you a couple of the questions and the steps that we think about as we think about putting real estate into a special needs trust and what that looks like. We work very closely with the ARC. We are absolutely partners when we have these conversations with families. And like Anna said, if you're thinking of a very specific question to yourself, just make sure it's generalized and not to your very specific situation with names and whatnot, because this is being recorded. So let's kind of jump into the next slide. And it's where do we even begin, right? So it always begins again with the conversation, but then initial discovery. So we kind of want to think about when you're thinking about, and this is the conversation I get all the time with families is my child is used to living in the family home. This is where they've always been. This is what they're familiar with. And I'm like, I totally understand that 100% when they're living with you, mom and dad. But when mom and dad are not there any longer, what does that home look like? Is because mom and dad may do so much of the work around the home that you don't think about. And if you're no longer there, can your child, the beneficiary, actually live in that home? So we always step back and we're like, okay, is there a physical limitation? Is the home ADA compliant? These are just thinking of things out loud. So as a fiduciary, when we transfer a home into a special needs trust, it becomes an asset of the trust. So it's our responsibility to make sure that that home is maintained, that it is, you think of it as an asset of the trust. So it's like you have a bond, you have a stock, you have a piece of real estate. So we really want to do the deep dive and kind of understand, is the home really applicable and ready for the beneficiary? Will there be future modifications? Because that's a cost. So we kind of want to know what the house looks like today. Will we need to modify it down the road for any particular reason? And ultimately, is it suitable? We know it's the family home, but if you're not there, is the home suitable for the beneficiary to live in by themselves or with a caregiver, whatever that may be? So once we have that initial kind of discovery conversation, and that is with the ARC, and if KeyBank needs to be brought into that conversation, we absolutely come into that conversation. We want to do a little bit deeper of a dive. So we're like, all right, so it's kind of like checking the boxes. Okay, made it past the initial conversation. This is kind of like what we look like. So what's the deeper dive look like? Well, now we want to know a little bit more about the house. So what's the current market value of the home? How old is the home? Because if the home, say, it's a beautiful antique old 150-year-old home, that may not be a good solution. It may be a beautiful home, but it may not be the best one for your child to live in. And then we kind of look at when's the last time the roof was replaced? Was it 30 years ago? So we think about all of the types of expenses that may come to be on the home itself. So what are the current, and we kind of look at the budget of the home. So what are your monthly expenses of the home? So whether it's the real estate taxes, what semi-annual, annual basis, what are you currently paying for your homeowners? What does that look like for coverage on the homeowners? Do you have a landscaper? Do you have a in-ground pool? So what maintenance do you do on the home on an annual basis? And kind of what does that look like in today's dollars? We absolutely want to definitely know about the insurance too, because what we do is we look and we compare an apples to apples comparison. We say, okay, you have a great homeowners policy through statewide and you pay X amount of dollars. Well, KeyBank, as a fiduciary and having a national trust real estate team, we also have insurance policies in place that we have thousands of pieces of real estate in that policy. So we'll look and we'll be like, can Key provide better coverage for you as opposed to what you currently have? So you understand the deeper dive concept here. We're really truly looking at everything as we go along. And then the size of the property. Love postage stamps because they're super easy to maintain. But again, if you're no longer there and your child, the beneficiary, is living on their own, and now they have 3 acres of property to mow because they want to mow the property and not have a landscaping company in place, like what does that look like? So we are going to peel back the onion and really understand truly what's with this property. And then the pool on premises and a hot tub. And I say that because who's taking care of the pool right now? If mom and dad are, well, that's going to be a future expense if the beneficiary can't. So we're going to be like, now we have to hire a company. Is the pool safe for the beneficiary? Or is that something maybe we need to look at another option? And then kind of getting into the septic side. Is it city water or sewer, or is it a well and septic? Because man, I have dug wells, not personally, but I dug wells, and sometimes it's difficult to find water. But then if you're on a city and sewer line, again, deeper dive, really trying to understand everything that goes with that home. Okay, have that conversation, check the box. Now we're going to get into the financial side of the house. This is great. Okay, we went through that initial discovery, things check the box and it looks really good there. We've done much more of a deeper dive on the home itself and like what goes behind taking care of the home and the costs. And then we get into like the financial side of it. So what's the value of the home? And we always think today's dollars because you don't have the crystal ball. I don't either to look into the future and be like, what would that house be worth in the future? But today's dollars, what are we looking at? What's the value of the home? Are you contemplating putting this into a first or third party? Third party, right? Because the first party, once you put a home in a first party trust, you're opening it up to Medicaid payback. You don't want to do that. Jen and I are like, no, no. There's always another option. So it's the third party that the home would be that you would want to transition a home into. Then we kind of look at what is the trust going to be funded with, as opposed to what the value of the home is, as opposed to what's your annual. That's why we did that deeper dive. What's the annual cost to maintain the home, from taxes to insurances to maintenance, upkeep, anything and everything. And then so there's a lot that goes, it's like financial planning on a smaller scale, but like, what are the monthly inflows and outflows that would be going into the trust or paid to the beneficiary? So if you have a lump sum that's going to fund your third party trust, and then you have this piece of real estate, I can tell you as a fiduciary, my number one concern and the ARC's number one concern is the beneficiary first and foremost. So we want to make sure there's enough funds to take care of the beneficiary. And if it becomes excessive where the home, like the trust can no longer support the beneficiary and the home, we may have to look at different housing options for the beneficiary. These are things we don't want to do. And I say that only because if it gets to a point where we have to relocate the beneficiary because the trust can no longer support the home and the beneficiary, that's going to really upset the beneficiary. Mom and dad are no longer there to console. If they don't have a great support group, then they're alone and they're like, well, now you're going to take me out of an environment which I really am comfortable with. So these are the things we truly look at very deeply and want to make sure that trust can support that home for that beneficiary's lifetime. If not, then, there are steps that can be taken, but these are the things we like to think about. And then that last bullet point there is additional monthly income received to assist with offsetting expenses. Is there anything else that is going to be funded into that trust? Maybe there's another family relative that has a life insurance policy that when they pass will fund into that third party family trust for the beneficiary. Just having all of that, the discovery of what financially will be funding this trust, whether it's today, future, or future from another family member. Now we get into that whole conversation. We had initial discovery, we've peeled back the onion, we've done the deeper dive, and now we've done the financial side. So then we're like, okay, things look great. We're going along. So now we kind of want to review some documents beforehand. And we do this ahead of time because we really want the family to understand, okay, If you're no longer here and the home is transitioning, we've had this conversation. And in today's dollars, everything looked great. So let us review kind of what does the deed look like in today's, like, just show me what the deed looks like. Show me a copy of the actual real estate taxes. Show me a copy of your actual homeowner's policy. And then we get into such things as, is it part of an HOA? Are there any restrictions or covenants on the property? We want to understand exactly what's tied to that property, because HOA expenses, that's another monthly expense. So if we forgot about that on the deeper dive, we're going to catch it here in the document review process. And then an occupancy agreement. So this is something that we built out. We know is very important for a family to understand too. It's basically an agreement that's saying, listen, you're going to live in the home. These are the responsibilities of, this is the financial responsibilities to the beneficiary. These are the responsibilities of the trustee. And one of the biggest things, and I think it's on the next page, we can jump into that later, is we just want to make sure that if there is somebody living in the home with the beneficiary, are they contributing, and how are they contributing, and what does that look like? So that occupancy agreement is really just going to lay out all of the parameters around living in the home. Okay, I think we're ready to go on to the next slide. Thank you. So how this is, and I'll keep this super high level, is how does KeyBank accept in real estate? This conversation that I just went through. So having all of that information up front and understanding what it looks like. So now we're down the road, mom and dad have passed, and now now it's time to accept the real estate into the trust. So we actually have, like I said, a national trust real estate team. So we will do that home. We'll have all the information on it. That home will go through committee. And like, once it's vetted out and we're like, yes, this home is appropriate for the beneficiary to live in, then it goes before committee and acceptance. Because we really want to make sure that nothing's changed over the course of time. And then once it's received in, then it's off to the races, right? So now the trust home is part of the trust. It's part of the assets of the trust. And then the trust will pick up on paying the expenses of the home and moving forward from there. The one thing I will note, because over the years, and I've sat on real estate committee for 15 years, you see some interesting things. There's a couple of things that KeyBank cannot have. And we say this, and this goes to all our clients. It's not just very specific to this space, but we can't have, like, if you own a business of breeding animals, not your dog got pregnant and now she's having pups, and that's just, the way, that's different. But if you own a breeding business, we cannot have that business run out of the trust. It's just one of the things that the trust committee has seen. Not so good things happen from that. So you can't breed animals living in the home that the trust owns the property. So operating any kind of business, but we kind of point out that the animal one specifically, because we've seen a couple of things go sideways. And then exotic pets. We've seen a couple of instances where things did not work out really well with exotic pets. And people are like, well, what's an exotic pet? There's not, it's not a gray area, but it's like a 10-foot python snake. I'm sorry. We've seen some really scary situations. Snapping turtles. I'll just give you two that real life scenarios that I have seen happen. Snapping turtles when they were little kids in the home living actually with the beneficiary because they were the kids, and that wasn't a good situation. So there are a few things to keep in mind when you are putting real estate into a special needs trust. And I just wanted to note out those few things. Okay, I think I'm good here. So what are the possible pitfalls that could happen? Like I said, the ultimate number one consideration is the beneficiary, and not upsetting, because when mom and dad pass, that's a rough time for the beneficiary anyway. So we want to make sure that things are very smooth and very seamless. So what we want, that having these conversations up front is very critical and very important, so that mom and dad have all the expectations in place on when we're transitioning real estate in. So some of the pitfalls to avoid is the size and layout of the home. Like I said, if it's a 5-bedroom center hall colonial and 3 acres, and that beneficiary can't maintain the home, that may not be a great scenario. Maybe a 2-bedroom condo that's on public transportation line is a better scenario for that beneficiary. Every case is different, but just kind of pointing out some of the things we've seen. The location of the home. Is it way out in the country where they have their closest neighbors 2 miles away? May not be a good situation or a scenario. So, and again, maybe the beneficiary has a part-time job and takes the bus to work. Is that home located on a public transportation line where they can hop the bus with no issues or problems and get to their job, which they probably love every day? And then the funds to support the home and the beneficiary. Our beneficiary is number one. We want to make sure that there's enough funds in there to take care of that beneficiary first. And if it's a very large piece of real estate and all of a sudden it's starting to really suck the funds out of the trust, we need to assess that because we want to make sure there's enough there to support that beneficiary for their lifetime and give them the best quality of life that we can. And then is the beneficiary able to identify issues in the home? This is probably the biggest bullet point on this slide because there's a difference here of being able to live in the home with mom and dad and then living by themselves. Can they recognize that there's a leak under the kitchen sink and know who to call and not wait 2 or 3 months and now that leak has turned into a flood and now the expense to fix that is much greater? A clog in the toilet, very common one. Do they know enough to pick up the phone and make a call, or are they going to try to use a leaf blower to clean out the toilet? Just giving you some life scenario, some real life, real time scenarios. And again, it goes to just recognizing issues or problems with the home, understanding that I have to call somebody to get this fixed, and then making that call. So those are the 4 pitfalls that I kind of came up with, and I know that Jen might touch on. Hey, these are some things that we solution sets. So with that, I think I'm going to pass this off to Jen and, we'll go from there. But thank you so much again for being here today.
Cindy, it took everything in my power not to unmute when you said there's no definition. I was like, you'll know an exotic animal when you see it. If you have any question, it's an exotic animal. So as Anna mentioned, my name is Jenn Crane. I'm a special needs attorney. I've had the privilege of assisting the ARC, getting to work with KeyBank over the years. Nothing I say today is going to constitute legal advice. This is all just generalities we've seen over the years and things we recommend. The biggest pitfall I, as a trust and estates attorney, see is a family sets up their sub-account with the ARC and then never does their estate planning. If all of this is going to work, it is a finely tuned machine. It is exhausting. The documents are not easy. No, I cannot make them more readable because the law has to do what the law has to do. So the biggest one we see, you want the family home to go into the trust with the ARC. Well, if you're working with an attorney like me, the very first thing I'm going to flag is this. And that's why you don't want to do your documents yourself. You want to work with an attorney who knows the ins and outs, because I know there's a pre-acceptance process and the ARC is not required to accept or keep the real estate. I say that one more time. They're not required to keep it. I've had clients say, I'm just going to dump it in the trust and there's nothing they can do about it. Well, I guarantee you there is. So it's really important that all of this works in lockstep. Now, by way of illustration, I've been in practice 20 years this month. I've had one family where I've said, yeah, it makes sense for the house to go in. One, because they had the money to sustain it. It was built for their child's disability. So there were elevators in the right places, ADA compliant tubs. They had a full-time live-in caregiver who was slated to become the guardian when mom and dad died. They did all the planning, and I said, all right, this makes sense. But in order for it to work, let's assume everything is perfect. Your estate plan has to direct the property to your trust. So if you don't do anything, let's say you never do a will, never do a trust, never do your estate planning, everything is going to pass according to the laws of intestacy. Intestacy is a big, fancy legal word that means your property is going to go the way the legislature thinks it should have gone. It may not wind up in the trust because there will be multiple fiduciaries before that who have the option to sell the property. If the debts of your estate, for example, are so large that the property has to be sold to pay them, this plan won't work. Let's assume you've done all your planning. You say, Jen, I've got my pour-over will and my revocable trust. What else do I need to do? Well, you need something we call a specific devise of real estate. You have to tell the trustee or the executor where the property is supposed to go, because otherwise they're not mandated to distribute it that way. It may be the long-time family plan that Jimmy is going to live in the home, but unless it's in writing, it's not binding. Another really important thing to keep in mind, and I'm going to ask Cindy to pipe in on this one, the property can't be encumbered by the time it gets here. There can't be a mortgage on it, right, Cindy? It's got to come free and clear.
Correct.
Okay.
Yes, absolutely.
I want to say it again. It can't have a mortgage on it. And the reason that matters so much is oftentimes in estate administration, how do we pay off the mortgage? We have to sell the house. So the plan doesn't work. Everything, we say it's like a game of choose your own adventure. All of the adventure has to work. So you have to have your documents. And this is assuming we've had the realistic discussion. Because most families I work with, they just want to make sure Jimmy has a place to live. So we have to talk about what that looks like. Then we have to make sure your estate planning documents do that thing. There's a lot of other steps that happen. We also need to account for the time lag between mom and dad's death and the property getting to the special needs trust. Even if you have all of your documents lined up, everything's ready to go, administration's going to take, best case scenario, 12 to 18 months. We have to account for that. Then you'll notice we all keep saying occupancy agreement. What are we not saying? Lease, because a lease can convey property rights. So if there's an occupancy agreement, if there's a lease, if there's anything else, that has to be sorted. It doesn't automatically transfer, and sorting it may very well get in the way of getting the property over to the trust. We also have to remember the property. So in Virginia, we have a concept where real estate drops like a rock. The minute you die, your will step in and say where the property goes. In Virginia, we can use a will as a deed. I don't recommend it, but you could do it. But what's going to stop the property from passing the way it's supposed to is titling designation. If you own the property with somebody else, let's say you put your daughter, Charlotte, on the property because you thought it would keep it safe. Well, if she owns that as joint tenants with right of survivorship, it's not dropping to your trust when you die. It's going to Charlotte. Or if you made her a tenant in common, she's getting her half. The titling on the property has to work with your estate plan in order to get it to the trust. All of this has to line up. And when we built this presentation, we all started from the horror cases and worked back, because if you plan, you want the peace of mind that this is going to run smoothly. So let's say you've done all of this. Everything lines up perfectly. The property is going to pass through your estate plan. It will drop into your trust with the ARC without a mortgage. And there's enough money to sustain the house and the beneficiary. Well, your fiduciary, your executor, your trustee needs to know that that is the plan, so they can work with the ARC to effectuate that. Because in Virginia, our fiduciaries have a tremendous amount of power and authority, and they can gum the works up with the best of intentions. So when you do your trust plan, your memorandum of intent, whatever the version is where you write down what you want for your loved one, it's really important to make sure your trustee, your executor, and the fiduciaries with the ARC, who's on the joinder agreement to support your loved one, all know what the plan is. Because otherwise we start scrambling because nobody knows exactly what we're doing. And the worst case scenario when we don't know what to do is we wind up in front of the men and women in black. we're in front of a judge with a suit for aid and direction, asking, how is this supposed to pass? Where is the real estate supposed to go? And all that does is eat up money from the estate. So planning, making sure the fiduciary, your executor or trustee, knows the plan and then knows what the ARC requires in advance is really critical. You've got to put these wishes into your will or trust because the fiduciary may need some extra flexibility. We're all working together. Let's say Cindy comes back to me and says, Jenn, we can't take the property. There's no way the trust can sustain it. Okay, I need the executor or the trustee to be able to sell it. If I've mandated they drop it to the trust, we got a problem. So when I give that property, I say, I give my house at 123 Smith Street to the appropriately named trust. If it is in the best interest of the intended beneficiary to do so, if it is not, I give my trustee sole, absolute, and complete discretion to determine the best arrangement. Now, yeah, that gives the trustee flexibility. You got to trust the trustee. You can't pick somebody that's not going to do the right thing. It's a game of push and pull. I can't have the language so restrictive, I call it hamstringing, that we can't make your plan work. Because what if Cindy comes back and says, Jenn, we can't keep the farmhouse. There's no way. There's, snapping turtle breeding ground. It's on floodland. It's next to 3 Mile Island. We can't keep it. But there's enough money to buy a 2-bedroom condo. We need to have the authority to be able to facilitate that. So all of it requires lining up. You can start with the premise, I want the property here, but then we have to back into it to make sure that it happens. Because again, they don't have to accept it. And if the document was so restrictive, if your will forces it there and the trustee can decline the property, go to court. Time, money, all expenses we don't want to incur. So make sure you review the language your attorney put in. Most people do not review their estate planning drafts before they sign the document. I tell folks, I don't expect you to understand the powers sections or the definition. That's my job. I have to make sure that's included. Your job is to read what I've written about your wishes and make sure I did it right. And I'll tell you if there's things I can and can't do. But if I don't know the plan, I can't put it into your documents, and I can't make this happen. We can't do it by sheer force of will either. Because the other thing to keep in mind, we generally recommend family trusts that feed the special needs trust. We very rarely recommend wills. That's because wills in Virginia are public record. They incur probate tax, and they are subject to supervision by the court. So you're having even less flexibility with a will because somebody's got to be signing off on everything you're doing. The trust is going to give more flexibility, more visibility for KeyBank as they're working with you, because they may be able to spot powers in the trust that we can use. So all of this is overwhelming and complicated and difficult. But that's the only way it's going to happen the way you want. And the very first thing is the realistic conversation. The realistic conversation of should the property go into trust? Is it best for the beneficiary, or is it what I want as mom or dad? It starts from there, and then the ARC and your attorney should be working in lockstep to make that happen. Anna, do we have questions?
Thanks so much, Jenn. Thank you so much, Cindy. We do have questions, so I'll move on to the next one. So I just wanted to go back and clarify. I said that if you have questions, you can put it into the chat. I misspoke. There's a Q&A button on the bottom of your screen, and that's where you can type a question in. Or going back to the suggestion earlier, If you'd like to react and raise a hand, you are welcome to ask your question aloud as well. So we do have a handful in the Q&A. The first one being, can the beneficiary contribute to the upkeep of the home, real estate taxes, etc., with their own earned income or SSDI benefits? So,
Cindy, that's
go
all
ahead.
you.
You go ahead,
I'll
Anna, and
do
then
the next
I
one.
have something
This one's
too.
all you.
I was just going to say that's something that we would be discussing in the first dive, I guess, into whether or not we would accept the property. One of the bullet points that Cindy had shared earlier is we will be talking about the inflows and just income that might be able to help offset with the property costs. And so they are able to contribute. It would just be something we would need to discuss ahead of time so that we can factor it in when we're budgeting for what the trust would be paying for versus the beneficiary. Cindy, I don't know if you had anything else to add.
Yeah, no, that actually perfect. But the one thing I would say though is just remember that the real estate is an asset of the trust. So we like to make sure that the trustee is responsible for paying those real estate taxes and the homeowners, so it never lapses. So that's the only concern. So those are, again, starts with a conversation. So
next question we have, can we buy an investment property now and put it into the trust before we die?
I'm going to say no as the lawyer on the call, or that could you? Yes. Is it a good idea? Absolutely not. Because if it's an investment property, you are likely renting it. You need that in an LLC. You need that in a legal structure that protects it. Now, a well-drafted estate plan to coordinate the LLC with your living trust, drop it in there at death, and then potentially give it to the trust with the ARC. But it's really important to remember there is a middle decision maker between all of this, and that's your fiduciary. Whoever you've named as executor, whoever you've named as trustee, before we even get to the ARC, right? There's this line of administration. So can we put the home, we covered it does need to be paid off. Can we put the home in our special needs trust document with the decision to keep or sell the property by the trustee? Yeah, in your living trust. You can do it there. Cindy, I don't think we can do it once it drops to the ARC.
no, you're right. The living trust is the best place for it for that decision.
Because once it gets to the special needs trust, the ARC and KeyBank are your trustee. They're making the decision.
All right. So next one, what happens if there's no family member, no family friend, no one to act as a decision maker? Who can be the decision maker?
So I'm going to say what I recommend in practice and then ask Anna and Cindy to. This is a common scenario we see. We don't see large families anymore. We just don't. I joked with my husband when I started working in this field, we didn't have kids. And I said, we need to have a bunch of them just because you see what happens. The question is, it all comes down to money. Can we pay somebody? Yeah, it sounds mercurial because it is, but that's the very first thing I go to. Can we hire care managers? Can we hire personal aides? Is there money? Okay, there's not money. Can we get insurance? Where can I find money? That's my response because we don't have access to public services that provide that. From where I sit, we have to come up with a plan for it. But Anna, you and Cindy are much better equipped to answer that than I.
It's pretty similar to what you shared, Jen, which is trying to explore every kind of avenue there might be. The other thing I would just offer is when we talk about decision makers, I immediately go to, are we talking about guardianship as well? Because if there aren't financial means to be able to afford one, or there's not someone who's willing or able to serve in that capacity, then the fail-safe would be guardianship of last resort. But at that point, I know you're at the mercy of who's available to do it. But otherwise, Jen, very much what you shared, which is exploring the avenues, paying for a care coordinator, maybe looking at a professional fiduciary, But it is a challenging and frequent question I know we face on a regular basis.
Totally, I completely agree, and it's sad that it's really, really hard to get to find a guardian, and the guardian of last resort. I mean, thank goodness it's there, but you're at the mercy for that last one. So
We can hire trust companies, and we do. I lean on that option hard because it'll be a vetted company. It won't be KeyBank, but it would be vetted like the OCC, all of that, because the trust company is always going to be there. They're always going to be there. It may not be the trust officer you know and love, but it'll be the company. So we can hire an executor, we can hire a trustee. The personal decisions are way harder. And again, we're just hiring somebody. That's unfortunately the best solution we've got.
So next question we have, I've marked answered for some of the ones that we've already touched base on. So I don't know if you all as hosts saw that, but we'll keep going along, which is, we have the next one, which is we have 3 children, one of whom has special needs. Do we need more than one trust for estate planning?
Yes. So I don't like killing other people's children off, so I'll do it to mine. My husband and I have the Crane Family Trust. And when the second of us dies, our trustee is directed to split into, we have 5 kids, 5 shares. When you have a special needs child and say you have a trust with the ARC, the trustee of the Crane Family Trust is directed to distribute that child's share to the ARC of Northern Virginia. I don't love nested special needs trusts. So let's say you did a standalone special needs trust or you didn't use the ARC, depends. I don't love having the special needs trust inside the family trust. You want to break it out into a separate document. It's just easier logistically when benefits agencies review it. But it's the same concept, right? Because the ARC joinder agreement is not inside your family trust. We direct out to it. The trustee is empowered to make the distribution there. So you'll need at least 2, right? Your family trust and your trust with the ARC. And then inside your family trust, you can plan for your other 2 kids.
Next one, can a trust transfer from state to state?
My lawyer answer is it depends. So the Constitution promises us that if a document is valid where it is executed, it is valid everywhere. However, that doesn't mean we accept it lock, stock, and barrel. So the best example and further proof of my belief that our legislature made up of attorneys is looking for job security. In Virginia, if your executor is not specifically or trustee vested with the 64.2 powers incorporated by reference, we have to go to court to get them if you want to sell real estate. So some states, Cindy, I don't know if New York is one. I always pick on New York and I say, the New York docs I've always seen have said I give my trustee all the powers under New York law.
mm-hmm.
Not here. So it's really important if you move to have the trust or will reviewed. Really important because yes, we have to accept it, but we will force the formalities. So you can wind up with a lot more work. I always tell folks it is cheaper to update your document than to pay me to argue about the Constitution, hands down. So yes, it can transfer. Is it a good idea? It depends.
I'm with you on that. It depends, but also like remember too, as you're building out your estate plan, think of it as your annual physical. Pull those documents out each and every year and review them. Are all the people that you've named as the fiduciaries still able to? Are they still with you? Or have they become incapacitated? So think of it as your annual physical is go and review your estate documents every single year. Sorry, I had to get that in there.
No, you're good. All right. So this one, can the Arc of Northern Virginia handle clients from Howard County, Maryland? We can. We serve clients that reside in Virginia, Maryland, or DC. Going back to can trust transfer, just because this is a perfect opportunity to share it. The Arc of Northern Virginia is approved to support clients that reside in those states or the district, but it doesn't mean that someone can't establish with us now and then move to another state. However, you would need to verify with the state's Medicaid to ensure that they would accept the trust in the new state of residency. All right. Are there significant administrative fees with maintaining real estate in the trust?
So basically, if the fees above and beyond the normal, just the fees for like managing as an asset, is if we were to buy or sell a home. So if we had to go out and purchase a real estate, then there's a cost associated with that. And it's typically between 1% and 3% of the value of the home. If we had to sell the home, same thing. We're preparing the home for sale. We're working with the real estate broker. We're doing all of that work. And again, that would be depending on the complexity of the transaction between 1% and 3% of the market value of the home. Those are the extraordinary costs above and beyond.
Cindy, I think this is another one for you. Can a home in the trust have rooms rented out to provide companionship and income to support those in the house?
So you have to be very careful about this scenario. Because one, if you're renting out a room for a companion, the trust, so who's hiring the companion in the companionship? Is it a caregiver or is it a companion? Is it a friend that's just living there to be the companion and cook, maybe do cleaning, like whatever that may be? Or is it truly a caregiver that one of the family members, a guardian POA, is hiring to live in that home? So you're looking at that as income, which would belong to the trust. And again, that ties into your occupancy agreement. So it's not an easy answer because I want to know a little bit more information around this one. Typically, we don't typically rent out homes, rent out rooms for companions. But again, it's a case, like we need to have a conversation around that to get a deeper understanding of what you're trying to do here. Because if you're relying on that income stream to help support the home, that's not solid for me.
My bigger fear is how the room is rented out. Did you just give that tenant rights? Because if you gave them rights, we can't kick them out. And I've seen without due process, without a full legal proceeding, and that played out to its extreme, has involved the police. So that's the last thing we want to do. That was my last horror story with a live-in. They had rights. There was a tenancy. So you got to be really, really careful with how that agreement is structured because you could unwittingly give somebody property rights.
Yeah, that's why that deserves a much bigger conversation.
So next question, can we purchase a condo for child to live in now and have it titled to a special needs trust now versus having parents as owners?
Well, this is like a twofold question. So that means you've established a relationship with the ARC. You funded a trust with the ARC, and now you're purchasing the condo. Either the trust is purchasing the condo, or you're transitioning the property into the trust, and then the trustee is maintaining the ownership and maintaining the home itself. Why I do like this scenario is because you're teaching your child to live by themselves. So when the case happens, when mom and dad do pass, that the child is already in their own home, they're established, they're familiar with that scenario. So again, this deserves a lengthier conversation because we want to do that initial discovery, that deeper dive, the financials around it. But I do love the thought process of set up your child now for success. Get them onto their own, living on their own, understanding and mom and dad are there to help. Hey, there's a leak under the sink. This is what you need to do. Do you live on the bus line? Great. These are the buses that you take to get to your job. I love that. So that is more important. That is very important to me. And us as a fiduciary is that you're setting your child up for success. So it's just a matter of having the initial conversation around, okay, is it a proper condominium? Is it great setup for the child? Is there enough expenses? What's the maintenance and upkeep? Are there HOA fees? All of that. So going back to that initial slide, check the boxes there, and then yes. But I love this. Thank you, whoever wrote that
Yeah,
question.
and I was just going to really highlight again, though, mentioning putting it into the special needs trust, making sure that the trust has the funds to maintain, because at that point you're transferring the ownership to the trust, and so the trust is accepting the responsibility of keeping the house or condo up to date. And so I've seen that before where we've had conversations and families want to do this, but the account balance in the special needs trust might be $5,000 because they weren't planning for it to be fully funded until the parent has passed away.
The other thing, once you transfer ownership to the trust owns it. You have lost right to the property. Taxes are going to change. Your trust is funded, so there's going to be an income tax consequence. You're going to start getting grantor letters for it. And the trust is now reportable to the benefits agencies. So pre-planning is not bad. However, there's a consequence to pre-planning, just to be aware of it.
All right. Next one, can funds in a special needs trust be used to purchase a home for the beneficiary? I think the answer I know the answer would be yes, it has the potential to do so, but we would need to evaluate what's in the trust and does it have the means to purchase property and still provide for the beneficiary long term. All right. How is the home inspected throughout the years to ensure it's livable, realistic to keep the property?
There's an annual inspection that is done on the property to ensure that everything inside and outside is as it should be, and that it's not declining.
If we buy a property now and move our loved one into it so the property can be put into the trust now so that everything is in our place at death.
You can do that. You just got to make sure your estate planning docs work. So if I read that as you buying it, so you own it, that means you can do whatever you want. You can put your child in it, it's yours, you own it. But then your estate plan has to, I tell my students it's a coat hanger, right? If this is your estate plan, it's got to drop down. That means you need to either have a deed putting the property in your revocable trust or transfer on death deed. Again, you can use your will. Why you would want to, I don't know. It's expensive. It takes more time. And then your will or your trust needs to direct where it goes. Now, I have a question for Cindy. Cindy, hypothetically, Virginia allows, well, this part isn't hypothetical. Virginia allows transfer on death deeds, which are sometimes a great and easy tool. What if there is an estate being distributed that will ultimately land there with the ARC and a transfer on death deed that's going to get the property there first? Is that okay? Can you do the transfer on death deed, or do you want it inside the family trust first?
So I've seen it where it goes inside the family trust first and then transfers over, and it's a much smoother process.
I think that's way safer because otherwise the property is going to wind up in there with nothing to pay for it.
Exactly.
So we have another one, which is how does the special needs trust intersect with ABLE accounts? I know I can speak on the ARC of Northern Virginia's behalf. It's case by case. If we're talking about real estate, ABLE might be able to contribute to some, going back to the earlier question of if there are funds that can help to offset the cost of maintaining the home, maybe the ABLE might be something that could do that. In terms of accepting funds from ABLE to trust, that's a possibility, but again, case by case. And then contributions out from a special needs trust to an ABLE account, again, case by case. Because if we're making a decision to accept property into a special needs trust, we don't want to be depleting the special needs trust by depositing funds into an ABLE account. I don't know if either of you have anything you'd like to add to that.
Everybody loves, exactly, use as needed. ABLE is not the solution to everything. You want to use it when you need it.
Does the trust earn interest?
I'm happy to answer. There's a variety of options that the ARC offers when for either a first or a third party trust for a self-funded or a family funded trust. So yes, it is invested, depending upon which option you choose, the trust does, so to speak, earn interest.
And those 4 objectives are available on our website if you were curious. We have an allocation guideline, so it shows what the investment objective offers and the ranges in terms of how they're invested. How does this work if we move or our kids are in different states?
How does it work with the beneficiary living in the home in the state of Virginia? So I just need a little more clarity around that question.
If you can just add on to it, I'll scroll down and elaborate on the question if you'd like, to the person who asked that. We have another one circling back to one of the previous questions. This seems concerning to me as setting up all this, and at the end, there's no one to act as a decision maker or help make the right decision for the beneficiary. So what's the point?
For me, the point is you can establish as much as you possibly can have control over, because otherwise it's the men and women in black of the likely Fairfax County Circuit Court. And they're all lovely people, but they won't know your child. So if there's no planning, lawyers are going to get tapped to step in, and likely you'll get somebody who's on a list somewhere willing to do this. But if we flip the question, how much can you take control over? You can still have your trust with the ARC. You can have your trust plan, because there's a lot of ways the trust can step into support. It can't make personal decisions, but that's not the only thing we need to worry about. There's the financial component and the personal component. So I know it sounds trite coming from me, but we do the best we can with what we've got. And we put as much in place as we can. And I think if you work with an estate planning attorney, they need to be cognizant of that. I've had clients come to me who can't afford to hire me. Okay, so here's what I'm going to do pro bono. Here's some state forms you're going to use. I'm going to check them before you sign them, and we're going to set up with the ARC. We've done that, and we can do that. Is it perfect? No. Is it better than nothing? Absolutely.
I'm just going to jump back to that question we asked for a little bit more information on. And so just a refresher, it was, let's see. How does this work if we move or our kids are in different states? And so the added context was parents are in Virginia, the child is in Florida at the moment. Should we do a special needs trust in Virginia or Florida? And can the trust with the ARC of Northern Virginia transfer to an ARC in Florida? So I can share, I'll answer a couple of those things, and then either of you feel free to chime in. But if you were to choose to set up a special needs trust with the ARC of Northern Virginia with your child living in Florida, I would say you'd first of all want to consider leaving it as an unfunded special needs trust. There's a section in the joinder agreement that we would specifically state that if someone resides, like for example, it's like an early termination clause, and what we would say is Social Security does not allow for early termination. However, you would be providing the authorization to the trust manager, the ARC of Northern Virginia, to work with KeyBank to transfer the account to another pooled special needs trust, perhaps in Florida, if the child continues to reside there. And Florida looks at the joinder agreement that was set up with the ARC and says, no, we're not going to accept this. Then we can move to another pooled special needs trust in Florida. I will say, is it going to be another ARC? I don't know. I don't believe there's an ARC in Florida offering a pooled trust, so we would likely be looking at a different organization. But we would be able to transfer it if the time came where we needed to. Anything you all wanted to add, feel free to chime in, but that was just the ARC's perspective.
The only thing I'll say is you want the trust in the place where the beneficiary lives, because it's going to be a nightmare for benefits purposes otherwise.
Okay, so we're coming up on time, so I'm going to stop at the question that we just received, and we'll go through what we have now, but that's, if Cindy and Jen, you have an extra few minutes to go beyond 11, we'll finish up with the last question that just came through at 10:57. So going quickly through what we have, can we put the current home in trust now while parents are living with the child?
That's can you? Yes. Do you? Should you? Probably not. Again, you're losing control over the house because once that house transfers into the trust, it's the trustee's responsibility to maintain and manage the house. So you lose basically your rights to just go in and say you wanted to put an addition on the house. You can't do that without trustee approval. There's a lot of implications that go with that. So I don't recommend putting the house in trust while everybody's living there during lifetime.
I also just keep going back to if the trust isn't going to be fully funded until the death of the grantor, we're probably not going to be able to accept the trust or the property into the trust at that point either. What option do you recommend is the least disruptive and most secure for the individual?
So for a living situation, again, kind of goes back to a couple of questions is if your loved one can live on their own and has that ability to, or with someone checking in on them, set them up for success and do it ahead of time while mom and dad are still there to help them through the process. And that's usually the least disruptive for that individual, typically is what we see. And the most secure in a sense of you've already got once you've gone through all that process and it's accepted in and there's enough funds and we've done all check the boxes, it's the most, you say most secure. The home is already, or the condominium is already in the trust. So it's a done deal and it's done. So it's the plan. It's just a matter of maintaining it at that point and not disruptive because when mom and dad passed, they're living in their own home. So that has nothing to do with the special needs trust.
I'm also just going to add, so before becoming the director of trusts, I worked in residential services for people with developmental disabilities, and I also served as a support coordinator for people with the DD waiver. And so we're talking here about real property, but one of the big things that I would stress is making sure that you start to work on the circle of support or the support services that this person will be receiving when they transition into their next living environment, so that at least they're used to a routine in the new environment and everything melds together as one. So it's not just the estate plan that's critical, it's also the support plan on the other side to make sure that your loved one is able to maintain continuity of care is one of the big things that I'd like to highlight.
Mm-hmm.
Cindy, can you repeat the fees for when the ARC owns and manages property?
Absolutely. So the fee, so as an asset of the trust, it's part of the market value. So that's the normal fee that's taken on the real estate. Anything extraordinary above that is if the trust has to actually sell the home or purchase a home. So that is an additional 1 to 3% of the value of the home, whether we're buying or selling, because of all that goes behind the scenes with preparing the home, working with real estate brokers, doing all of the closing with the attorneys. All of that encompasses into that 1 to 3% cost.
Okay. This might be very basic, but I thought I would ask. I'm just beginning to plan. I have both a family trust and a special needs trust done with an attorney for my son. I never thought that I would need the ARC to administer or be involved. What does the ARC actually do in this case? Are my trusts set up somewhere that I don't know of?
If you haven't named the ARC will have nothing to do with it. And that is something I see all the time, is just generally naming the ARC to take care of it. There was an attorney, who shall remain nameless, who did that a lot in Northern Virginia, just generally named the ARC. There's no trust there for your child. There has to be a joinder agreement with the ARC in order for the money to get there. So if the ARC isn't named in your documents and for a role they can fulfill, they can't be there. Now, Anna, is there any other trustee role that the ARC will serve besides the sub-account?
In terms of special needs trusts, no. I mean, we work with KeyBank, we work in tandem. We serve as the trust manager, sometimes known as a trust administrator. KeyBank is the trustee that we've appointed, and the trust itself would need to fall under our master trust agreement. And so I have had that question raised before where I'd like the ARC of Northern Virginia to be our trustee or our successor trustee, because we have a personal trustee, but just in case we want you named. The ARC is not a trustee. The ARC is a trust manager. KeyBank is our trustee, and that is a conversation that we should have beforehand Because if you don't have us named, but maybe a successor trustee wants to move it to us, then there's a whole different process that we'll have to pursue to explore even accepting the trust at that point. Can we leave the home to an individual who will live with the individual with legal obligation to manage affairs and be caregiver?
You can do anything you want, but think about it. You're leaving that
Terrible
home.
idea.
Like, oh no. I mean, yeah, I'm like, you can do anything you want, but you're leaving a home to an individual. You're not leaving a home to a corporate fiduciary. You're not leaving the home in trust. So who's to say that that individual can't turn around and sell the home? That is not a good situation. You may think everything is great in today's terms, but what happens if something happens 5 or 10 years down the road and that individual now you've left it to them so they can sell that home at any point in time? And then what happens to your loved one?
And the legal obligation has to attach to the property in a way that we can enforce it.
Mm-hmm.
So I've had people ask me to do a deed to give the house to the caregiver and say, don't worry, I have a caregiving agreement. Nope, because I've just given that person property rights. Your caregiving agreement isn't going to attach to the property right. So in that situation, we're going to do an LLC and we're going to make the individual an employee of the LLC, and the property is going to be owned by the LLC. There's going to be a trustee managing the whole thing, because you could have the best caregiver in the world. They could be wonderful. And if they are in a car accident and it is their fault, their creditors can attach their property. You've given them that house outright. What could happen to it?
We've got 2 more, one's pretty quick. So would all of the same considerations you discussed also apply for standalone special needs trusts?
Yes.
And then last question. If circumstances result in the beneficiary not being able to live in the home that is in the trust, can the home be used to generate income for the trust by renting it or selling it?
So you're basically turning the trustee into a landlord. So that is a separate conversation. Do we do it? Sure. Should we do it? Is a whole separate conversation. So we'd have to know a lot more around this. Again, like where the home's located, what are we looking at here on renting it out, and does it make sense?
And that's specific to renting it, right, Cindy? Because the second part of that question was, or selling it, which that I know we
Selling
have
it,
a
yes.
much easier way of doing it, because
Right.
it's generating revenue for the special needs trust that will ultimately continue to benefit the beneficiary, or explore an alternative housing option that might be a better option.
Mm-hmm.
So I just wanted to clarify. Selling it, sure. That goes back to something that Jenn and Cindy both shared, which is making sure that you understand the house is owned by trust. So the trust is going to be making these decisions. Renting it, to Cindy's point, landlord's a little bit different. We would need to have a conversation, but is it best practice? I defer to Jenn's nod of a head of no, but so.
I agree.
The thing I always remind folks, and Cindy, I'm stepping way outside my lane, so feel free to slap me. The trustee has an obligation to invest the money so it initiates a return. They can't. We had a case where a trustee sold a house in McLean worth like $16 million. They put it in a non-interest bearing checking account for, I think, 10, 12 months. You can't do that. If you're the trustee, you have a fiduciary duty under the prudent investor standard. It's got to be making money. So where I'm looking to, and I'm guessing, Cindy, you would say the same, how much money can I get if we sell this and invest it and it generates income?
Mm-hmm.
How do I best turn this into an asset that works for the beneficiary? Because I've never had a family say, I want you to get as little money as possible out of the trust corpus. That's why we use corporate.
No, and I agree, because sometimes there's a confusion over, well, this is going to generate $2,500 a month. Well, if we invested it prudently, it could generate more than that.
Yep. And that's why you want to use a trustee like KeyBank, because they know how to do this.
Mm-hmm.
It matters.
All right. Well, that was it for questions. I'm sure there are more, but that's just what we have time for today. So again, I just really want to thank both of you, Cindy, Jenn. It was a pleasure to have you both on. I hope that this webinar was informative for those who attended and for those who watch it on YouTube at a later date. very much appreciated all of your time and really just appreciate continuing to work together.
Thank you. It's been a pleasure to be here, and I hope everybody has a wonderful weekend.
Anna, thanks so much for hosting us. Anytime I get to be here next to Cindy, it's an exciting time for me.
Aw, same here, Jen.
All right, everyone, you take care.
All right, take
Bye-bye.
care.
Bye-bye.